In November 2020, at least two whistleblowers filed complaints against the Public Defender's Office with San Diego County. The complaints alleged retaliation, hostility, racial insensitivity, and conflict of interest. The allegations followed the firings of three deputy public defenders, including Zach Davina, who earlier this month won a $2.6 million judgment in a wrongful termination lawsuit against the county. County spokesman Mike Workman told KPBS in an email that the county's Office of Ethics and Compliance investigated the whistleblower complaints, but Workman said the probe was suspended when officials learned that two of the three fired deputy public defenders might sue. Dan Eaton is a San Diego legal analyst.
Once litigation begins, it is not uncommon for whatever investigation is in process to be put on hold, which is what the county essentially did. And that's because the litigation process itself has a whole different set of rules for finding out what happened.
This raises questions as to whether anything has been done over the past 2 years about the alleged hostile work environment inside the public defender's office. KPBS asked the county for details on the investigation. When was the probe launched? How many people were interviewed, and when was it suspended? The county refused to comment, but Eaton says county officials had choices.
A county doesn't have to put an investigation on hold.
Here's what we do know about the investigation. Lawyer Chris Ludmer represents ex-deputy public defenders Davina and Michelle Reynoso, who has also filed a wrongful termination suit. Ludmer says he notified the county on November 24th, 2020, that litigation was pending. That was about 3 weeks after the whistleblowers filed their complaints. Ludmer says the county never contacted his clients for an interview about the complaints. However, the county did forward the complaints to public defender management. Testimony during Davina's wrongful termination trial revealed that in early December 2020, a supervisor in the public defender's office said in a letter to the county that an internal HR investigation report had determined the whistleblower complaints were unfounded. That's the same report public defender Randy Mize testified during trial that he signed, knowing it contained false statements by supervisors in his office.
I'll bet 10 to 1 that decision to put the investigation on hold was dictated by the lawyers in the litigation, or lawyers for the organization.
New York University law professor Stephen Gillers says an employer is obligated to investigate allegations of discrimination, harassment, and retaliation. In other words, the law doesn't change just because an employer has been sued.
The concern of the organization is to make sure that things are being done properly, whatever the legal fallout in the litigation.
In Davina's case, the jury agreed that as a gay man, he was discriminated against for his gender expression. At one point, Davina was asked whether he was too flamboyant and animated during his tenure review panel. The jury also found that Davina faced retaliation. Gillers says the pressure only intensifies on a workplace to investigate when jurors agree with the plaintiff, such as they did in Davina's wrongful termination lawsuit. That jury also found that the county did nothing to prevent discrimination and retaliation against Davina.
The heat is on, and they have an affirmative obligation to figure out what it is that was going on that persuaded the jury to award a multi-million-dollar verdict.
Amita Sharma, KPBS News.